All right, we're back, and we can now have the conversation with Professor Richard Wokocha, who is an associate professor of public law in River State. Prof, thank you so much for your patience. Please tell us what the laws are that guide the impeachment procedure of or for a state governor or against a state governor, and how do those laws apply to the ongoing situation as we know it in River State?
Well, the legal framework for impeachment in Nigeria is Section 188 of the Nigerian Constitution. And that section provides a three-pronged or three-tiered process. First, whenever a petition or a complaint, allegations of misconduct is leveled against the governor or deputy governor, and such petition is signed by 1/3 of the total number of members of the House of Assembly of that particular state. Once that petition is presented to the Speaker is expected by the law, by the Constitution, to circulate that petition to all members of the House and then send a copy of that petition to the person accused. And within 14 days, he is expected to convene the assembly for them to decide without debate, just vote on the motion whether or not the allegation should be investigated. If members, up to 2/3 of the members, agree that the allegation should be investigated, then the Constitution further requires the Speaker to write to the Chief Judge of the state and mandate him to set up a 7-man committee of impartial Nigerians who are not card-carrying members of any political party and are not civil servants or public servants. Now, these 7 men will look into that complaint. They will have to hear the governor or deputy governor, whoever is accused of the misconduct. He can represent himself by himself or through a lawyer chosen by him. And if that body finally finds that allegation to be untrue against him, the impeachment proceeding ends there immediately. But if they find that the allegation is correct and that what is alleged was done by him, then the Speaker is again required by the Constitution, upon receiving that report, to convene all members within 14 days. If 2/3 of those members reconvened, approve that report, then the governor stands removed, with effect from that approval by 2/3 of the members of the assembly. As I said, if otherwise, if the committee report is otherwise, that the offenses were not, or misconduct was not established, then the proceeding ends there. So that's the proceeding. What has happened in Rivers State is an information issued by the Martin Samehule, the Speaker, as at yesterday morning, that they had commenced impeachment proceeding and that a notice will be served on the governor. He has received impeachment complaint or petition, allegations against the governor, and that it will be served on the governor. But between then and now, there's been a lot of drama. One party claiming that 24 members sat to take that decision. The other party that, among others, was suspended, the majority leader who was suspended, has subsequently also announced that they had held a session in which the Speaker, as at the morning hours, has been impeached, and he has been appointed the Speaker by the House. And he claims they had, 26 members in attendance.
Okay.
And, so the situation right now is that we don't know if there is Speaker and who is Speaker that will take any action on the purported impeachment proceeding that Martin Samehule announced has been undertaken.
Yeah, thank you. Yes, sorry to interject here, but what do the laws say, or which laws guide the authenticity, acceptability of, and legality of the proceedings in the House of Assembly? Is it the House rules that are framed by each specific state House of Assembly, or are we looking to the Constitution of the Federal Republic of Nigeria? The reason I'm asking this is because we would like to know.
Rules are.
Yes, sir.
The House rules.
Please go.
The House rules are framed based on the powers granted to the House by the Constitution. But the Constitution, in a way, makes the basic provision. It talks of quorum, and it says you require 1/3 of the members of the House to form quorum to sit. And it says the Speaker will preside over such sitting. And it further says in the absence of the Speaker that the Deputy Speaker can preside. And in the absence of both the Speaker and the Deputy Speaker, that the House will resolve by a resolution there on one of them who is to be mandated to preside over the meeting.
Okay.
So I think the constitutional provisions are the critical rules concerning.
Yeah, but Prof, does it say, yes, Prof, does it tell us where the sitting should hold? Is there any limitation placed on where the decisions taken outside the confines of the assembly chamber, the official assembly chamber? Number one. Number two, if yes, where else can they sit? Number three, is there any limitation placed on decisions taken without the official mace? So if, let's say, Edison AA's camp has the mace, official mace, and Martins Ameole's camp doesn't have the official mace, does that affect the legality of their decisions?
I think not, because first, let me take the questions as you asked them. Is there a place designated for sitting? The law does not state, the Constitution does not insist that they must sit at a particular place. But the presumption is that because we have spent public funds preparing a place for the sitting of the House, that is deemed to be the sitting place. But of course, the law cannot insist on a sitting place because it can have an exigency that may make it impossible. The place could be facing renovation. The place could be damaged by arson, as happened in the last 48 hours. There could be a natural calamity. Anything could happen to a structure. So the law simply emphasizes what forms quorum. And I believe that what makes a place hallowed chamber is the convergence of the authority of constituencies that are represented there. So whenever 1/3 of representatives of the constituencies in the state gather, when they have up to 1/3, they have formed quorum, and whatever else has to be done can be resolved by resolution, because forming quorum means that they have obtained the authority to act. Now, on the mace, there is no mention of the mace in the Constitution. The mace is customarily regarded as the instrument of authority of the assembly, but there is no mention of the mace in the law. So I don't think that when quorum is formed, that the presence or absence of the mace can determine legitimacy or illegitimacy of the decision of the assembly. Nothing in the law says that. If there is something like that in the House rules, it does not equate with the Constitution and will not render what is legitimate under the Constitution illegitimate, because it does not conform with an inferior legislation or regulation like the House rules.
Professor Wokocha, just a side question. My producer didn't ask me to ask you these questions, but please permit me an informal one. You were a lecturer of Nyesom Wike in law school, or rather in the University of Port-Harcourt Department, Faculty of Law, if I'm not mistaken. What sort of student was he?
Sorry, I didn't get the last part of your question.
Oh, sorry about that. I thought we lost you. Yes, just a quick one, very short one. You were a lecturer to Nyesom Wike in the university, if I'm not mistaken, in law. What sort of student was he?
Oh, the minister was a gentleman in the university. He was rather quiet. He was not a loud student. He was not as vocal, if you like, as he is now, while he was in the university. In the university, perhaps he wasn't very involved in activities because he was more involved in activities in the main city, that is, in society. Because if you look at his history, it wasn't long after he left the university that he became the local government chairman of Obiabo. So he must have been more busy out in the real society where politics was happening than inside the school. From the school perspective, he was a quiet person who did his work and minded his business.
Thank you so much, Professor Wokocha. It's always a pleasure to talk to you.
Great pleasure. Thank you very much for having me.
Thank you very much.